Number 95.
Ready for court, please?
Counsel, you have any rebuttal time? Would you like any rebuttal time?
I'd like to reserve 5 minutes.
5 minutes. Go ahead.
Good afternoon. May it please the Court. I'm Andrea Osert for the State of New York. Joseph I.I., the Article 10 respondent in the first case being argued this afternoon, was a classic Harkavy patient. He was a member of the precise population that the legislature wanted considered for possible involuntary treatment under Article 10.
Ms. Oser, what about the Williams case? Is that fatal to your position, People v. Williams?
Not at all.
Why not?
Because that goes to whether this custody was colorable at the time, and now we know that these individuals can't be resentenced, that resentencing would have been improper, but we don't rely on the resentencing here. We're looking at the facts as they existed at the time, and we have offered 3 versions, 3 ways that you can view these individuals as eligible for consideration under Article 10. One doesn't rely on their custody status at all, although we think this Court doesn't have to go that far since these 2 individuals were, in fact, in state custody.
There's no question that if Joseph I.I. had not attempted to escape, so that he had remained an OMH patient, that he would have been a Harkavy too.
That's exactly
Correct?
right, and you can consider him as effectively in that Harkavy custody.
So the issue is whether the transfer to DOCS changes his status?
Well, that's correct.
How does the fact that he was at one time in OMH custody,
Yes.
how does that qualify him as a detained sex offender within the jurisdiction?
Well, the legislature specifically provided in the subdivision G5 that's at issue here to cover all of the Harkavy patients, anyone who had been transferred from
Anyone who at any time was with OMH, is that your argument?
after September 1st, 2005, for that year and a half prior to the
But
statute's
answer my
enactment.
specific
Yes.
question. How does it qualify him as a detained sex offender within their jurisdiction when he's with DOCS?
Well, there are, as I say, there are 3 ways that you can look at this.
Tell me one.
Okay. One is that you can consider him as basically constructively in OMH's custody.
How so?
But for the post-release supervision, he would have remained at OMH. If you treat it as a nullity, which is what my opponent asks you to do, then he is effectively restored to the status quo ante. He would be
If
in
it's a nullity, why is he restored back to OMH?
Well,
I don't
that's
understand.
where he was, and they hadn't completed a substantive review. They had never made a determination that he didn't
Yeah,
need
but I'm
treatment.
in trouble with the logic of that. I mean, it's within
Well,
the...
maybe this would help. Would it help, Your Honor, if they had
Yeah.
issued a piece of paper to retain their hold, a detainer, for example, or if they had, in the second case being argued...
Send them back to DOCS, but retain their...
Return him to me if and when you're done. Sometimes they do that. In fact, in the second case being argued today, they did issue a detainer to the county jail when the respondent engaged in a violent act. He was retained temporarily in local custody.
So your argument
So
is...
that might just be a procedural flaw.
Your argument is, in effect, he's still in OMH jurisdiction? Is that what
That's
you're-
right. He was never discharged with a determination
So
about
even
his treatment needs.
if he's unlawfully in DOC's custody, DOCS would still be an agency with jurisdiction? That's your position?
Well, that's an alternative view.
On
An
your first
alternative-
theory, OMH would be the agency with jurisdiction?
That's correct. That's correct.
But it wasn't, but OMH then would have had to send a notice, but then you're saying they don't have to send the notice to
Well,
themselves?
that would be potentially a procedural defect.
Isn't your alternative theory simpler, that he was detained by DOCS because he was detained by DOCS, and the statute doesn't say lawfully detained, it just says detained?
That's exactly right. On that theory, he was in fact in DOC's custody. DOCS was the agency responsible for supervising him, releasing him.
Suppose you lose this case, and
Yes.
you can't proceed under Article 10.
Yes.
Can you then proceed under Article 9?
The State would certainly need to turn to other tools at its disposal
So,
to see.
I guess what I'm saying is, in your view of this, we're just talking about which article of the mental health law you lock him up under. There's not a question of giving him more rights one way or the other?
Either way, he's entitled to a hearing. That's exactly true. Some have described the procedures under Article 10 as more protective. But
And
So-
I mean,
Go ahead, I'm sorry.
I'm saying in Harkavy,
Yes.
in Harkavy 1, Mr. Harkavy, I guess, was arguing, no, don't use Article 9, use Section 402, and you were saying, no, the state anyway was saying, no, Article 9 works. Now you've switched sides. Although of course Article 10 has replaced Section 402. Is there one article that's better for the alleged offender or better for the state than the other, or is it just a question of picking the right one?
Well, I think that what the legislature did in enacting Article 10 was it sought to fill the very void that you had identified in Harkavy 1. Neither correction law.
Well, we didn't actually say we didn't. We said there was a problem. We didn't say there was a void.
Well, you said that
that
neither scheme was really quite appropriate to someone who, in fact, had been in custody, since Article 9 usually applies to someone, not required, but someone who was most recently convicted.
Why isn't Article 9 sufficient now?
Why isn't it sufficient?
Yeah.
It
Why
may be.
should we extend?
It's a different substantive standard to meet the mental illness for Article 9 versus the mental abnormality.
Clearly you're asking us to extend Harkavy 2, right? To cover this situation where...
Well, this individual was in that very situation with the wrinkle, as you say,
Yeah, but now
that he
there's-
was returned.
But now there is this wrinkle.
Yes.
Why can't you just proceed under Article 9? Why do we have to keep extending
If the
that?
Article 10 is dismissed, if this court goes with that result, then the state would have to look at those options.
Would that be, as Judge Smith, I think, was driving it, would that be equally good?
It's a different scheme
Isn't
with a
it
different substantive
easier for
standard.
you?
It's not clear that he would qualify.
Isn't it easier for you? I mean, Article 9, you have to prove that he is mentally, I forget the words, but
Mental
basically he's mentally
abnormality.
ill and a danger.
Yes.
Here you have to prove something much more specific, that he's a dangerous sex offender. Why isn't Article 9 easier for you?
Well, the definition of the underlying mental illness is somewhat different. Just as
It's narrower in Article 10, though, isn't it? I mean, as I understand Article 9, all you have to be is crazy and dangerous.
well, a mental illness. This is a mental abnormality that predisposes you to engage in dangerous sex offenses. So it's a different substantive standard. And for now, the state
Is there anybody who could be detained under Article 10 who could not be detained under Article 9?
Is there anybody who could be, who could not be? It's possible that you could meet one substantive standard and not the other.
Now, give me an example of somebody who is subject to being detained under Article 10 but not under Article 9.
Well, it would be a psychiatric diagnosis, a question of that they meet one standard and not another. I'm not sure.
I guess I'm under the impression, or maybe you can correct me, that the Article 9 standard is relatively broad and inclusive. That if you're mentally ill and you're dangerous, that's all you need under Article 9. And it seems to me that everyone who's under Article 10 is either mentally ill or
Well,
is mentally ill and
it's the
dangerous.
mental illness piece that's different. The definition of mental abnormality is different from the definition of mental illness. So an individual could
So you
satisfy
could be
one
mentally
standard and not another.
You could be
I'm not saying
mentally
there's not an
abnormal.
overlap.
You could be mentally abnormal but not mentally ill.
Satisfy one standard and not another.
Who's mentally abnormal but not mentally ill? Give me an example.
Well, some of the individuals who have been considered under Article 10 have an
Antisocial
personality disorder that
disorder.
may not qualify them for, a mental illness under Article 9.
That's, I mean, aren't you raising a substantive, you're almost saying that as you read Article 10, anybody who's a criminal by disposition can be locked up?
Well, they need a diagnosis from an expert that
But
they
Don-
suffer
but
from a
antisocial-
condition or disorder that predisposes
But if you
them.
count antisocial personality disorder as a diagnosis, then it reaches, I mean, that's almost a
Potentially.
synonym for criminal, isn't it?
And predisposes them to engage in sex offenses specifically. I mean, there's no question that the statute is designed both to remove dangerous people from the public as well as to provide protection for them, or at least to provide some treatment or supervision for them.
If this case were to arise again, these exact facts,
Yes.
now that we've determined the PRS in
Yes.
some cases was not lawfully imposed,
Yes.
what should happen? Should they would try a person like this for the escape crime and then sentence them to docs on the escape crime? Or do they return them to the OMH? so that
I'm
you
not
keep
sure I'm
them
following
under
the
the jurisdiction.
hypothetical.
If we disagree with the state's position in this case,
Yeah.
I'm trying to determine what then would
The
happen.
next time someone at OMH engages in an act of misbehavior, it could either be treated through the criminal route, or it might change the services or supervision that the individual is under at the facility. Is that what you mean? If they didn't have the
Yes.
option of returning them
Yes, they
to
could
DOCS
either
for
keep them in
PRS.
OMH or
Sure.
try them through the criminal system and give them a sentence of imprisonment.
That's right, and
correct?
in that
If
case,
found
as I
guilty.
said, I think OMH would have issued a detainer saying, we
Okay,
want this
Tom.
person back.
Okay, thank you. Counsel?
Thank you, Your Honor. Good afternoon.
You're here on a HABE, right? This is a habeas proceeding.
Pardon me?
This is a habeas corpus proceeding.
Correct.
Correct, okay. And I guess the first question is whether your client is lawfully in DOC's custody at the time that the Article 10 review began.
Right. Clearly, he wasn't under the determinations by this court in Garner that administrative post-release supervision is a nullity.
He was clearly not lawfully in custody, and there it's equally clear that he was in custody.
He was in custody, absolutely.
Yeah, well, I mean, if he had been, suppose this situation had arisen before Article 10 was enacted, could the state have proceeded under Section 402?
Yes, they could, but they would have had to afford him a hearing in advance of his transfer.
Okay, but why? But why wouldn't
From
why
Doc
wouldn't you have had the
Stelnick.
same argument under Article 402? Wait a minute, he's not lawfully in custody, and this is for prisoners.
Oh, no. I think I took your question to mean, Your Honor, when he was approaching the expiration of the sentence.
No. Suppose this case exactly as it is today, except that Article 10 was never enacted. 402.
They could not have returned him to Doc's custody.
They couldn't, but they did.
Right.
Yeah, assume those facts.
Right.
There's a guy who's wrongly in Doc's custody. You don't have Article 10. You have Section 402 and you have Article 9. What do?
The writ has to be granted. He's not lawful.
I understand that I understand that he's entitled to be released by Docs. The question is, they want to commit him. They want to commit him civilly as a sex offender.
Okay.
Can they do it under Section 402?
No, they would have to.
Can they do it under Article 9?
He could potentially be admitted to a psychiatric hospital under Article 9 upon his release from Doc's.
Well, a release which he's entitled to immediately.
Right. If a writ was filed.
But since he's not lawfully in Doc's custody anyway, he could be committed under Article 9 right now.
Correct. But he wouldn't be subject to Article 10. Because
Okay, what I'm sort of blundering around is what's the difference? Why is it such a big deal to you whether they can commit him under Article 9 or Article 10?
Well, there's a major difference. I mean, under Article 9, it doesn't provide for lifetime supervision upon release from the hospital, whereas Article 10 does provide for lifetime post-release supervision and the ability to return somebody to a secure sex offender facility.
So I guess that's a useful answer, but I guess what's bothering me, I guess I'm beginning to understand, is in a sense, you and the state have switched sides since Harker v. 1, haven't you? Back then, you thought Article 9 was bad and Section 402 was good. Now you're telling me Article 9 is what I want. Don't give me Article 10.
Well, I would admit that if you were afforded an Article 9 hearing, if that's what the Court determines should happen here, the Article 9 hearing would not put them in a secure facility for sex offenders. It would put them in a psychiatric hospital.
Who runs that? Who runs that?
Well, for mental health.
All right. Now, one of the agencies defined under Article 10 is one having jurisdiction over someone as OMH. So if they do an Article 9 and he ends up in an OMH facility, they could immediately begin an Article 10, making all the allegations they've done now.
He
correct?
has to meet the Article 9 standard for admission to a psychiatric hospital.
Right. But I mean, they're
And
making.
he has to be in OMH custody under Article 9 as a result of a sex offense.
Well,
so if he were released
wait,
by
don't leave me that fast. It doesn't say that. It just says that, that the agencies that can do this include the Office of Mental Health.
Well, the OMH custody is.
So if he's under their jurisdiction, and they can just say, this man, not only is this man sick, but he qualifies under Article 10, we're going to sue him. We're going to be in civil proceeding under Article 10. They are an agency that can do that, right?
The OMH custody that is sufficient for Article 10 jurisdiction is a transfer from DOCS.
Doesn't say that.
Yes, it does. 10.03G5 says that the person has to be transferred from directly from DOCS to the Office of Mental Health pursuant to Article 9 to
No, you're right. I mean, that's when you're talking about what you want to talk about today, which is detained sex offender.
Correct.
But when they're talking about an agency that has the jurisdiction to do this, OMH could be the agency from which they could transfer someone, right?
They can be an agency with jurisdiction, yes.
Okay.
But in order to be an agency with jurisdiction, he has to be a detained sex offender. It's not enough that there be an agency.
Oh, I see your point. You're saying if he's under if he's in OMH for something other than being a detained sex offender, they can't touch him.
Correct.
Okay.
I guess maybe the question I've been asking 17 different ways, I'll ask it an 18th way. If your side had lost in Harkavy 1, and as a result, they had proceeded as they were, the state proceedings, it was proceeding at that time, and Article 10 had never been enacted, would your clients be better off today?
Yes.
So you wish you'd lost that case?
Yes, and I'll tell you why. And I'll tell you why,
It
because...
spurred legislation, that's what happened.
Well, I mean, I think that he would be entitled to an Article 9 hearing. And what we're saying is if this Court finds that no current custody is required, and it goes back, he has to be afforded an opportunity to determine whether he met the Article 9 standard for admission from DOCS to OMH. He's never been afforded that opportunity. He did demand a hearing. He was sent back to DOCS prior to being afforded that.
Is there any significance, Counselor, the fact that he was once with OMH? Their argument seems to be to a significant degree, well, he was there, so, they still sort of have him in some way, shape, or form.
There's also a distinction, in answer to your question, between this case and the next case, which is that when he was sent back to DOCS for the violation of the administrative post-release supervision, Article 10 had not taken effect yet. All right? So OMH could not have issued or initiated the Article 10 process for him. It's different in Humberto G because Article 10 had taken effect. So on the date of his discharge from OMH, he was not subject to Article 10, could not have been subjected to Article 10. Now, I think that's an important distinction between the two cases. But the other problem that the State has here is that if you look at R50, which is also attached, a clear copy is attached at Addend 12 to our brief, on the day they released him, they said, look, he doesn't have a mental illness. There's no Axis 1 or Axis 2 diagnosis. I mean, he never had a mental illness. He never
So
was.
he has no string still attached to OMH at that point.
They discharged him back to DOCS. DOCS took him illegally.
Even though the action that put him in this predicament was that he engaged in an escape from OMH?
That's not a crime, Your Honor, under People v. Ortega. The site is 69 New York 2nd, 763.
That's why I said an act. He engaged in an act while he was in OMH
Right. Well, that's
custody.
one of the functions of psychiatric
and that's
hospital.
what got him
But
into
it's one of the
this
functions of a
situation.
psychiatric hospital or an OMH facility is to contain people, to punish him for attempting to escape when the reason he's in this secure place is so he can't escape. It makes no sense. The fact of the matter is he wasn't mentally ill. He didn't need to be there. They're using the OMH hospital as a holding cell for DOCS. That's what they're doing. They knew when his sentence expired on August 3rd, 2006, they knew he would not be subject to Article 10 because his sentence had expired. So let's put him in a hospital, wait till Article 10 gets initiated, and we'll use that admission to the hospital as a predicate for his Article 10.
But everything you've just said could be said about a guy who was not who was lawfully on post-release supervision. The unlawful post-release supervision has nothing to do with the argument you just made.
Right. I think if he had been discharged from OMH.
I mean, but don't we have a narrower question before? I mean, you're suggesting, I think, that there are that either Article 10 raises constitutional problems, or that we have to construe it narrowly to avoid them, or that it's unfair, that there are problems with the Article 10 procedure. But don't we have today the narrower question of whether this particular class of people, the people who are unlawfully who are given bad PRS sentences, whether they're under Article 10 or Article 9.
I think that's a secondary question.
Do we have any other question in this case?
Oh, absolutely. The first question is current custody, lawful custody required? There's two elements to it. Is current custody required, and must the custody be lawful?
Oh, well, whether the custody is lawful is the question that that applies primarily to these people with a bad PRS sentence.
You don't get to that until you find that current custody is not required, because the State is relying exclusively in this case on 10.03G5. 10.03G says that the offender, in order to qualify as a detained sex offender, the offender must be in custody. Then G goes on to enumerate the 6 subdivisions or types of custodies that qualify the person as a
Are you saying that if Joseph had been given legitimate PRS, had lawful PRS, that this case would come out the same? You still have a case here?
The G5 would not apply, but the state could apply via G1. Upon his release from Doc's custody.
Okay. Now suppose he were on PRS and hadn't violated it, and he were out in the street. Would G5, he was originally a Harkavy 1 or Harkavy 2 person. He was sent to the mental hospital. Then he's released. He's out in the street subject to post-release supervision. Can they proceed under Article 10 against him?
If the post-release supervision is lawful, yes, they can. When he nears anticipated release from post-release supervision. Under G, that's G1.
If it was real, if it was legal.
Correct. I mean, I think, aside from the early decision and this Court's decision in Garner, which invalidated the administrative post-release supervision, we now have an additional issue as a result of People v. Williams, because his judicially imposed sentence expired August 3rd, and the PR, at that point, it's over. There is no PRS, there's no jurisdiction to impose.
Mr. Levine, if we have a case identical to this, only the person has already been confined. In other words, there's already been an Article 10 finding and sentence. And he's been there, I don't know how old the statute is now, but let's say he's been in there for 2 years. Does he then come back and say, I know I've been found to be a dangerous sex offender, and I know I'm under this confinement because of that, but my PRS was wrong 3 years ago. You have to release me?
The case is not, this case is not about the PRS. This case is about the fact that he was discharged from OMH custody, no longer in a lawful custody.
Let's assume my facts.
In other words, that after he went to DOCS, that DOCS initiated the Article 10 and the Article 10 was granted.
Mm-hmm.
I think then, the People v. Williams, it's a jurisdictional defect. You can't, it cannot supply the predicate. That PRS.
So we would release him?
Yes.
All right, even though he'd already been, all of the dangerousness and all of the need for confinement and treatment, it's a treatment statute too, that we would say, you should have this treatment, but because.
It would be an issue of waiver. The Court would have to determine whether these defects, the PRS defect, could be waived and whether it could be revived, and that's a separate issue. But again, I go back to Judge Smith's point, which is, there is Article 9. So it's not like the State does not have a remedy, but there's a significant difference between an Article 9 confinement and an Article 10 confinement. The Article 10 confinement involves a much greater deprivations of liberty. That's what the Federal District Court said in MHLS v. Spitzer.
If someone is in custody under Article 9, they're in an OMH facility under an Article 9 order, can an Article 10 proceeding be initiated before they're released?
If they were discharged.
In other words, can you be transferred from Article 9 to Article 10 custody?
If they qualify under Subdivision G5, which means that they would have had to have been put in OMH custody directly from DOCS, where they were serving a sentence for a sex offense, directly to OMH after September 1st, 2005, and they must still be in OMH custody.
Why not under
Yes.
6? Why not under 6?
I'm sorry?
Why not under 6? Instead of 5, 6. A
Well,
person.
I mean, if there's been a prior determination or a prior
Doesn't say
adjudication.
prior. It just says a person who has been determined to be a sex offender requiring civil management pursuant to this article.
I think what that sex subdivision is intended to do is that you have somebody who qualifies under G5, actually qualifies, still in OMH custody. And by the way, in Harkavy 2, the respondents on the Article 10 in that case, in Harkavy 2, were all still confined in OMH custody when this Court said the State could proceed via Article 10. But in answer to your question, I think the problem is that that you have these parallel provisions for holding people. You've got parole, and you've got judicially imposed PRS, and then you've got Article 10. So you might have somebody in Article 10 who commits a crime or violates parole and is sent back to DOCS legitimately, not illegally, but legitimately.
I take it like you stab a fellow patient,
Correct.
right?
Then what Subdivision 6 does is it preserves the Article 10 jurisdiction because you were previously adjudicated under Article 10. The fact that you were released from OMH under Article 10 and sent back to prison to serve out your sentence does not defeat Article 10 jurisdiction. That's what subdivision 6 does.
So what happens at the end of that criminal sentence? Do you go back to OMH
Yes.
custody?
Yes. I mean, the Article 10 jurisdiction is there.
So that's a different-
There are some cases now that are discussing whether you keep the Article 10 in a state of an adjournment, if there's a review, or does the state just refile when the...
Yeah, but their OMH continues to have a role, right?
Correct, because...
Even though he goes back.
Because at the time of the initiation of the Article 10 application, the person was in OMH custody, still in OMH custody, and that's what David Adent says. The custody, when that Article 10 applies when the person is in lawful custody when the Article 10 process is initiated. In this case, the Article 10 process wasn't initiated until 14 months, or 18 months after OMH discharged Joseph II.
Thank you.
Thank you, Your Honor.
Councilor Rebuttal.
Just a couple things. I think the legislature's use of the term agency with jurisdiction may be somewhat misleading, and it needn't be read in the sense that we think of a court having legal jurisdiction over
What does
a
it mean?
subject matter. It was intended as a catch-all phrase to capture.
But the defined term, isn't it?
It is, and it captures the various forms in which a state
Well, and
may
it says-
be
it
exerting
says an
control.
agency
Care,
responsible-
custody, control, agency responsible for your release.
For
which Dobbs
supervising
was,
or
in fact,
releasing.
at this point, under a reasonable view of the law as it looked at the time. And in fact, the courts that have so far considered whether docs should be immune from damages liability, the one appellate court to have considered that issue has said that that is privileged. And federal district courts have held docs officials to be qualifiedly immune, the ones that have
I mean,
reached.
as I understand what's really,
Yes.
I'm having trouble with what's really going on here, but I guess, Mr. Levine explains it to me anyway, what's really going on is that the law draws a distinction between people who are in custody and people who are out, and treats the people who are out somewhat more favorably.
I think that's right, but I think...
Why does it do that?
Well, there's certainly a greater liberty interest for someone who's out, but I think that you can create...
Why, wait a minute, why is there a greater liberty interest for someone who's out than somebody who's in and should be out? Seems to me like the second guy has at least as much legitimate interest.
Well, I don't think that's generally considered to be true in the parole context where you're revoking parole versus denying parole.
Well,
That's a bit
if
of a
he's law-
tangent.
yeah.
But my point is that this statute is designed to address the mental health treatment needs of someone who has in fact been in custody nearing the end of their release, who may still be perceived as dangerous. It serves a different purpose. And it's a different form of treatment that's provided.
If he gets released and
Yes.
spends one day as a free person under no form of custody at all, he can be just as dangerous, and you can't
Yes.
apply Article 10 to him. Why is that?
Well, in some circumstances, that's Article 10 does authorize a court to, if he's at liberty when a petition is filed, the court is ordered to return him to the appropriate form of care or custody pending the probable cause hearing. So.
Well, when
but-
the petition is filed, but
Yeah.
he has to be in custody when the whole process starts.
Yes, it is by and large designed for the individual who has in fact been in custody. I think there's an argument that G5 is somewhat unique because it was designed to address a discrete population of individuals, and the legislature could contemplate that their status might have changed in that year and a half. But again, this Court doesn't have to make that kind of broad ruling here where these two individuals were in fact in custody. And we're not aware of the State seeking to apply Article 10 to anybody who is in fact at liberty. So that's not an issue the Court would have to reach here.
How would you make the rule? I'd asked your
Yes.
opponent about someone who is already an Article 10 inmate who's been found to be,
Yes.
and it turns out that his PRS was illegal, and therefore he says, I was illegally detained at the time under the new People Electoral Joseph I. I'm entitled to get out. Does he win?
Well, I think there is a question about whether certain arguments had been waived, but we do have a case where the Article 10 process wasn't permitted to reach its conclusion because of that very circumstance. It turned out that Harkavy patient was only in DOC's custody because they were there for a PRS violation where PRS had not been imposed, and the Court didn't allow the State to continue with that. So a ruling here doesn't govern in that case, but it is arguable that that person, too, was in a colorable form of jurisdiction at the time. So, okay.
Okay.
Otherwise, we'll rest on our brief.
Okay, counsel.